A House Judiciary Committee hearing turned confrontational when Congressman Joe Neguse questioned Homeland Security Secretary Kristi Noem about a $220 million DHS advertising campaign. Neguse alleged that one contractor received $143 million despite being a newly formed company with no known federal contracting history, while Noem defended the program as a highly successful effort to deter illegal immigration. Watch the exchange and then stay for the analysis, where we'll break down the contract controversy, federal procurement questions, and the broader debate over government spending and border enforcement.
I want to discuss in greater detail the expansion of advertising in your department under your tenure, and I believe you testified regarding some of these matters yesterday in front of the United States Senate. In particular, I want to discuss the department's $220 million ad campaign. This is the ad campaign that featured you at Mount Rushmore. You're familiar with this ad campaign, correct?
I am familiar with it. It was an ad campaign that was...
I'm going to ask you some questions about it, Madam Secretary. So, as I understand it, this is a $220 million ad campaign. It's split between two contractors. One of those contractors got $143 million. That contractor is called Safe America Media, correct?
Correct.
Okay. That company is affiliated with a former political director of the National Republican Congressional Committee. Now, yesterday you testified, I think I'm quoting you right, you said, quote, or in reference to this contract, that, quote, it went out to a competitive bid. Do you stand by that statement?
It was a no-bid contract where two vendors were
It was a no-bid
chosen.
contract.
If it would have been a no-bid contract, if I'm using that correctly, it goes out to two different vendors.
Correct. So it was not a competitive. Let me try to explain what the discrepancy, because a competitive bid is very different than a no competitive bid, and I'll just explain why. We know that your testimony yesterday, when you said, again, I'll quote, it went out to a competitive bid, is untrue. The reason we know it's untrue is because under federal law, your agency is required, whenever the agency decides to skip competitive bidding, to file a notice with the public explaining why. And in this case, your agency filed a notice. You're aware of that, right? Justification and approval for other than full and open competition. Your agency made a decision not to proceed with competitive bidding, and one of the contractors that got the award was this Safe America Media Company that received $143 million.
Many vendors got the chance to look at that contract and to participate in it.
Well,
so that is why the two of them were chosen.
That's inaccurate, Madam Secretary. I'll read from the notice from your agency. Given the immediate action to significantly reduce illegal immigration and border crossings, DHS identified 4 companies. 4 of the hundreds of thousands of companies in the United States, you identified 4. One of those is this Safe America Media Company. Where is Safe America Media headquartered?
I don't know.
I don't know either, Madam Secretary. We can't find it. We can't find a website. We did find an address that's registered for this company. Do you know where that address is?
Is there a problem with this contract?
I'll tell you about it.
According to
Madam
law,
Secretary, the
address
is registered to a political operative. Madam Secretary, the company, and then I'll give you an opportunity to respond. The company is registered to a political operative in Virginia. Do you know, just by way of example, whether this company that received $143 million in taxpayer dollars, has it ever done work for the government before?
I don't know. I can't.
The answer is it has not. And do you know why we know that? Because it was incorporated 8 days before this contract went out. You want the American people to believe that this is all above board? Yes, that $143 million of taxpayer money just happened to go to this one company that doesn't have a headquarters, doesn't have a website, has never done work for the federal government before, and is registered, apparently, or attached to a residence from a political operative. And of course, one of the subcontractors of that contract, as you know, is a political firm that's tied to you back when you were governor of South Dakota. The reason why I ask these questions is that this is taxpayer money. And I presume, I don't know this for a fact, but Senator Tillis noted yesterday the way in which your agency is blocking the Inspector General from 11 different investigations that it is trying to conduct. I don't know if this happens to be one of them. I certainly hope it is, because eventually the facts will become public in this regard. And there are serious laws implicated, conflict of interest laws, federal procurement laws, that I believe
all
merit...
followed, all done correctly,
Was
all
it
done legally.
all done correctly?
14 billion impressions from that marketing campaign.
Sure.
It was money spent in this country and in 8 different countries that illegal migration was coming from.
Madam Secretary,
overwhelmingly effective.
We all
$39
understand the argument that you've made, that somehow this ad campaign on Fox News of you at Mount Rushmore has led to millions of people self-deporting. You're using millions of dollars of taxpayer money in this way. It is fraud, and ultimately, I think there's going to be accountability. And I yield back, Madam.
Can I speak to the IG?
Yes, you can. Quick.
The IG has been told repeatedly, in writing, verbally, on the phone, that he can have access to anything at the Department of Homeland Security. He can. He doesn't need my permission to come and brief members of Congress on the Hill. He just needs to provide a scoping memo, which is what every single IG gets from every single department and agency. All intelligence agencies require a scoping memo. He just hasn't done that. He wants unfettered access to every single thing in the department, and that's not the process, and that's not any other IG has demanded that.
This exchange highlighted a growing battle in Washington over government spending, federal contracting, immigration messaging, and oversight accountability. Representative Joe Neguse focused his questioning on a Department of Homeland Security advertising campaign that reportedly cost approximately $220 million. The campaign was designed to discourage illegal immigration and promote border enforcement policies. The controversy centered on one contractor that reportedly received roughly $143 million of the total contract value. Neguse's argument was straightforward. He questioned whether the federal procurement process had been conducted properly and whether taxpayers received appropriate transparency regarding how such a large contract was awarded. A major point of contention involved the distinction between competitive bidding and limited contracting procedures. Federal agencies typically use competitive bidding processes to maximize competition and ensure taxpayer funds are spent efficiently. However, there are exceptions under federal procurement law that allow agencies to limit competition under specific circumstances. Neguse argued that DHS initially characterized the process as competitive while procurement documents suggested the department had limited participation to a small number of selected vendors. His criticism was not merely procedural. It went directly to public trust. When large federal contracts are awarded, especially contracts involving hundreds of millions of dollars, lawmakers often scrutinize whether the winning companies possessed relevant experience, operational capacity, and a demonstrated history of performing similar work. One of Neguse's strongest arguments involved the contractor's apparent lack of public visibility. He suggested that the company lacked an established public profile, had limited publicly available information, and appeared to have been incorporated shortly before receiving the contract. Those allegations immediately raise questions because government procurement systems generally evaluate factors such as past performance, organizational capability, financial stability, and technical qualifications. Critics of such awards often argue that newly formed companies should face additional scrutiny when receiving major government contracts. Supporters may counter that new companies can still possess qualified personnel, experienced leadership teams, or specialized expertise even if the corporate entity itself is newly established. That distinction is often at the center of procurement disputes. Neguse also raised concerns regarding potential political connections. Throughout American history, procurement controversies frequently emerge whenever contractors have ties to political consultants, campaign officials, former administration personnel, or individuals connected to elected officials. Importantly, political connections alone do not prove wrongdoing. However, lawmakers frequently argue that such relationships justify closer examination to ensure taxpayer dollars are being distributed based on merit rather than political influence. That was essentially the concern underlying Neguse's questioning. The congressman repeatedly emphasized that this was taxpayer money and therefore deserved rigorous oversight. On the other side of the exchange, Secretary Noem focused almost entirely on performance outcomes. Rather than debating procurement details, she argued that the advertising campaign achieved its intended objectives. Her defense relied heavily on effectiveness metrics. Noem cited billions of advertising impressions and argued that the campaign reached audiences not only inside the United States but also in multiple foreign countries that have historically contributed significant numbers of migrants attempting to enter the United States illegally. This reflects a broader strategy that has become increasingly common in immigration enforcement policy. Rather than focusing solely on physical border enforcement, governments often attempt to influence migration decisions before individuals begin their journeys. The logic is straightforward. If potential migrants receive information about enforcement policies, detention practices, asylum restrictions, or removal procedures before traveling, some may decide not to make the trip at all. Supporters argue that deterrence messaging can reduce illegal crossings while saving resources that would otherwise be spent on enforcement, detention, processing, and removal operations. Critics question whether such campaigns actually produce measurable behavioral changes and whether the spending delivers sufficient value relative to its cost. That broader policy disagreement formed the backdrop of this hearing. Another significant issue involved oversight and inspector general investigations. Neguse referenced concerns regarding access to departmental information and ongoing oversight efforts. Inspectors general play a critical role within the federal government. They are tasked with identifying waste, fraud, abuse, and mismanagement inside federal agencies. Their independence is often viewed as essential for maintaining public confidence. When disputes arise between agency leadership and inspectors general, Congress frequently becomes involved because lawmakers view oversight as a core constitutional responsibility. Noem strongly rejected suggestions that her department was obstructing oversight. She argued that investigators had access to departmental information and that disagreements centered on procedural requirements rather than outright denial of access. This dispute highlights a recurring challenge in government oversight. Agency leaders often argue that certain procedures exist to protect sensitive information, maintain operational security, or ensure investigations remain properly scoped. Oversight officials may argue that those same procedures create unnecessary barriers that slow investigations and reduce transparency. Both sides frequently claim they are protecting the public interest. The hearing also revealed a broader philosophical disagreement about immigration policy. For supporters of the administration's approach, the advertising campaign represents a proactive effort to discourage illegal immigration before it occurs. From that perspective, preventing unlawful entry is less costly and more effective than processing cases after migrants arrive. For critics, the concern is not merely the policy objective but whether public funds are being spent appropriately and whether contracts are awarded fairly and transparently. Those concerns become even more significant when large sums of taxpayer money are involved. At its core, this hearing was about two competing questions. First, was the advertising campaign effective? Second, was the contracting process handled appropriately? Secretary Noem focused almost entirely on the first question. Representative Neguse focused almost entirely on the second. The effectiveness question can be evaluated through data on migration trends, border encounters, enforcement outcomes, and campaign reach. The procurement question requires examination of contract records, vendor selection processes, performance evaluations, and oversight findings. Those are separate questions, and both can be important simultaneously. A program can be effective while still raising procurement concerns. Likewise, a contract can comply with procurement rules while still producing poor results. That distinction is often lost during political debates but remains central to understanding exchanges like this one. The broader significance of this hearing extends beyond a single advertising contract. It reflects growing congressional scrutiny over how federal agencies spend taxpayer dollars, how contracts are awarded, and how immigration enforcement strategies are being implemented. As future audits, inspector general reviews, and congressional investigations continue, additional facts may emerge regarding both the contracting process and the effectiveness of the campaign itself. For now, the hearing presented two sharply different narratives. One side argued that taxpayers deserve answers about a multimillion-dollar contract awarded under questionable circumstances. The other side argued that the campaign delivered measurable results and advanced an important national security objective. The ultimate judgment will likely depend on future oversight findings, procurement reviews, and the evidence supporting claims made by both sides. What remains clear is that the debate over government spending, immigration enforcement, and federal accountability is far from over. If you enjoyed this analysis, let us know in the comments. Should Congress focus more on whether government programs are effective, or more on how taxpayer dollars are awarded and spent? Subscribe to Capitol Oversight for more coverage of major hearings from Washington and beyond.